In his sentencing of Jamie Rothwell, Judge John Potter delivered the following statement. In this case, I am to sentence 10 defendants. They are each to be sentenced in relation to a variety of offenses which came to light following 2 police investigations, Operation Dryer and Operation Chairs, respectively. Other defendants have already been sentenced as a consequence of these investigations in the Crown Court, but not by me. The operations were instigated, in part, following the police in the United Kingdom receiving in 2020 evidence from investigating authorities in France and the Netherlands. This evidence illustrated that the authorities had been able to breach the encryption within specialized mobile phones, known as EncroChat phones. The server for the EncroChat network was based in northern France. The UK police received large quantities of digital material which had passed between these mobile phones in the form of text messages and images. The contents of this material illustrated organized criminal activity taking place on a very significant scale. The material revealed this activity between March 2020 and June 2020. The criminal activity discovered was being undertaken by the users of these phones, known as handles, with the assistance of others. On the EncroChat network, codenames were given to handles in an attempt to conceal their true identities. Codenames like Livelong or Keyhole or Sickplane were used. This did not stop the phone users being correctly identified from the material, because on many occasions, users, in the mistaken belief that the encryption on their EncroChat phones would never be compromised, proved willing to place identifying data on their mobile phones, making it plain who the user of their phone was. Their trust in their EncroChat phones in this regard was misplaced. They thought they could act with impunity, but they were wrong. Once attribution of a phone was established by the police, the identity of those involved in the organized criminal activity became clear. Each of the defendants I am to sentence in this case were, at differing levels, involved in this criminal activity. The more senior amongst them within the organized crime group used the EncroChat phones. Others working for these senior members did not. Having access to an EncroChat phone was a matter of trust within the criminal underworld. The phone in each case cost approximately £11,000, and they were deliberately used by criminals to avoid detection by the authorities, an aggravating feature of their offending. The criminal activity discovered within the digital material revealed the existence of already established conspiracies to possess firearms and ammunition on a large scale with intent to endanger the lives of others. The firearms and ammunition were often acquired from others before being either used or stored and then possibly sold on at a profit. The digital material showed that on specific occasions, unlawful agreements were made by some to cause specific individuals very serious harm with the use of acquired firearms. Acquired guns were discharged on at least one occasion, and one person was seriously injured. On another occasion, it was agreed by others involved in the firearms conspiracy that a man called Paul Cooper should be murdered by being shot, although in fact he was never physically attacked. Also discovered within the digital material was evidence of established conspiracies to supply large quantities of different types of controlled drugs, including cocaine, heroin, and ketamine. The total quantities of these drugs agreed to be supplied to others within these conspiracies was on an industrial scale, measured at least in hundreds of kilos during the time scale of the drugs conspiracies. The value of these drugs ran into millions of pounds. The drugs were usually acquired from others in bulk, several kilos of drugs at a time. Those others were either overseas or close to the point of importation of the drugs into the UK. The drugs were then sold on, often in kilo blocks or part thereof, and sometimes underwent an adulterating process to bulk them out and increase their value. They were usually sold on to other drug dealers, many of whom, in turn, were part of the EncroChat network. The drugs trade generated very large sums of cash, amounting to several millions of pounds. Conspiracies to transfer and distribute this money between those involved coincided in time with the drugs conspiracies, operating side by side. In the case of some conspirators, this led them to enjoy a lavish lifestyle, having benefited from the misery and harm caused to others, locked into the cycle of drug abuse or indirectly affected by it. For example, victims of crimes that may have been committed by those desperate for money to fund their drug habit. Each of the defendants fall to be sentenced in this case on the basis of offending during the period of the relevant count on the indictment and not activity outside those dates. They must each be sentenced consistent with the role they undertook within the particular conspiracy concerned. An estimation as to the role a defendant took in a conspiracy is required given the nature of the evidence in this case. For example, in relation to the quantity of drugs a conspirator may have been directly involved in and the time during which he participated in the conspiracy. It is obvious from the digital material that dealing by some of the defendants in guns, ammunition, and drugs did not start on the first day that EncroChat data was obtained. Where a defendant is to be sentenced within conspiracies to possess firearms and/or supplying drugs over a considerable period of time, as opposed to on a single occasion, I view the period of time of this offending as an aggravating feature in their case, because continuing dealing results in greater harm being caused. I also view as an aggravating feature that the supply of firearms and ammunition in this case was to other organized criminals heavily involved in trading in large quantities of Class A drugs and other criminal activity. In assessing harm caused by these conspiracies, I am required to take into account not only the harm that was caused, but also that which the conspiracy concerned was intended to cause or might foreseeably have caused. I must come to a fair but realistic assessment of the overall scale of the conspiracy's actual and intended operations. Each defendant is to be sentenced in relation to more than one count, and it follows that the totality guidelines apply. The entirety of the offending behavior of each individual defendant will be reflected in the sentence imposed individually upon them, my ensuring that the sentence imposed is just and proportionate in all the circumstances of that individual offender and the offending he falls to be sentenced for. I shall impose concurrent and consecutive sentences where appropriate to reflect the different types of conspiracies and the nexus of offending between the offenses agreed to within them. Jamie Rothwell, you are 38 years of age. You have previous convictions recorded against you, which make worse the offenses you fall to be sentenced for today. I shall explain how this is the case when I consider aggravating features to be applied in your case. You are to be sentenced in relation to 6 offenses: conspiracy to possess firearms with intent to endanger life, conspiracy to possess ammunition with intent to endanger life, conspiracy to supply cocaine, conspiracy to inflict GBH with intent upon Liam Burnsner, conspiracy to inflict GBH with intent upon Liam Burn Jr., conspiracy to supply ketamine. You pleaded guilty to these offenses before me on the 5th February 2025. You had previously pleaded not guilty, and a trial against you and some of your co-defendants had started in July 2024. That trial had to be stopped, and the jury discharged after you were stabbed and injured in custody during its course, meaning you were then not fit to stand trial. No responsibility lies with you for this exceptional turn of events, and in the circumstances in my discretion, I am prepared to provide credit for plea to you as 15%, notwithstanding the first trial started prior to any indication of any guilty pleas from you. Your role within the firearms, ammunition, and drugs conspiracies was a leading role. You were, the evidence I heard makes plain, at the top of the organization involved in this activity. Your business interests principally involved you buying and selling these items in great quantities. You used an EncroChat phone. Your handle name was Livelong. You issued orders to others, and you expected them to be obeyed. I heard evidence from your co-accused that they feared you. You obtained wealth by having access to millions of pounds of cash. You lived for this and other reasons for much of the time in Portugal or Spain, where you had access to an apartment offering panoramic views of Barcelona. You circulated pictures of this apartment and the vista on your EncroChat phone. You arranged for the purchase and storage of automatic firearms and live ammunition, most notably at least one AK-47 machine gun and more than one shotgun, with your co-accused. These firearms were acquired with compatible ammunition available to be used within them. You supervised the purchase and storage of these specific weapons, in particular with Morris and Close. The AK-47 was acquired on the 15th of April 2020. It was subsequently stored by Morris with the assistance of another co-accused, McDonough. The digital material shows you personally having access to and marketing or selling a vast arsenal of weapons. In conversations with another handle called Tubby Turn, you discuss having sent 300 straps guns home and having access to machine guns and an anti-tank gun. See lines 841 to 846 in the SOE chart. At line 1001, you tell Tubby Turn that you sell a lot of Glocks, i.e. automatic pistols. At line 5934 in the SOE chart, Tubby Turn sends to you a price list of weapons and ammunition available to you for purchase, and at line 8885, you send an image of an anti-tank gun to another handle called Local Bluff, a reasonable inference being that this is available for purchase from or via you. This is dealing in firearms on a sophisticated and significant scale and reflects high culpability on your part and on the part of others willing to assist you. Your willingness to use firearms you acquired to cause harm to others is evidenced by material from Operation Chairs and your guilty pleas to conspiring to inflict very serious injury upon Liam Byrne Snore and his son Liam Byrne Jr. in April 2020. You were in conflict with the Byrne family. On the night of the 24th April 2020, you sent a man pretending to deliver pizzas to the family address in Warrington. He was armed with a firearm. That man at your command discharged the firearm 3 times through the door of the address, causing injury not to either Liam Byrne Snore or Jenner, the intended targets, but to David Barnes, Liam Byrne Jenner's stepfather. Mr. Barnes suffered gunshot wounds to his leg. Your willingness to resort to violence to settle this and other disputes is also apparent within the evidence outlined in the SOE chart. At lines 2732 to 2741, you discuss with another handle called Defender the level of harm you were willing to inflict upon your enemies, in this instance someone referred to as Leon Cullen and his associates. Your drug dealings were on an international level. You arranged for drugs to be sold and distributed throughout the UK and also in Ireland and in other parts of Europe. You maintained a bonded warehouse from where drugs could be distributed. A conservative estimate of the amount of Class A drugs you were involved with in the period of the conspiracies, according to the evidence I considered at trial, would suggest you dealt in over 200 kilos of cocaine and 5 kilos of ketamine. You also dealt in heroin in bulk quantities. Valuation evidence places this quantity of cocaine alone being worth £7 million. A kilo of cocaine being sold at around £35,000 per kilo at the time of the offending in this case. You were also involved in the transfer of just under £1.2 million in money from criminal activity. You oversaw the adulteration of Class A drugs that your close aide James Close learned how to conduct on behalf of the conspirators. You increased your profits accordingly. This was drug dealing on the most serious commercial scale, involving quantities of drugs far beyond Category 1 levels within the guidelines. You have lived much of your life as a professional criminal, involved in serious organized crime. The offenses you fall to be sentenced for graphically illustrate your willingness to follow this path and cause loss and misery to others as you do so. In some cases, previous convictions aggravate the offenses. Defendants in this case fall to be sentenced for. Rothwell has 16 convictions recorded against him for 25 offenses, including robbery with a firearm in 2003 and possession of Class C drugs with intent to supply in 2007. In respect of each defendant, I have read the large number of testimonials, letters, certificates, and references provided to me. I have read the individual letters some of the defendants have sent to me. I shall attach appropriate weight to this material accordingly. Each advocate asked me to consider delay in these proceedings as a mitigating feature. Where it is true that the delay in these proceedings cannot be attributed to the actions of a defendant, I am prepared to extend some mitigation accordingly. I make it clear that the delay caused by there being a retrial in this case is not the fault of any defendant. In relation to Jamie Rothwell, I accept that the time you have spent in custody has caused you to reflect upon your criminal past. I note in particular the references I have read from members of staff where you are or have been detained. I remind myself of the harm caused to you in custody during these proceedings, and I shall take account of the days you spent in custody in Holland awaiting extradition. You continue to enjoy the support of your family. In sentencing Rothwell, Rourke, Close, Makinson, Morris, and McDonough, I am obliged to assess dangerousness in deciding the type of sentence to be imposed upon them. I must do this because of the type of some of the offenses of which they have been convicted. These offenses are specified offenses as defined by Section 306 of the Sentencing Act, 2020. The test I must apply is whether the defendant whose case I am dealing with poses a significant risk of causing serious harm to members of the public by the commission by him of further specified offenses. In assessing this, I must take into account the factors set out in Section 308 of the Sentencing Act 2020. Addressing Rothwell, the judge said, "You have a previous conviction that falls within Schedule 14 of the Sentencing Act 2020, robbery with the use of a firearm. This creates an assumption of dangerousness within the statutory provisions. You played a leading role in the firearm conspiracies, including the acquisition of the AK-47 with ammunition, a lethal weapon on any view. You placed hundreds of firearms within the United Kingdom on the evidence and offered for sale many more, including an anti-tank gun. Your willingness to use or authorize the use of firearms to settle disputes is clear within the events of the 24th April 2020, which led to the serious injury to Mr. Barnes. At one point, you refer in text exchange to being involved in a 6-month war with a person with whom you were in conflict, during which you say you went on a rampage. The dangerousness test in your case is satisfied. Given your background and the facts of these offenses, you are likely to remain for some time a criminal who presents a grave risk of causing serious harm to the public, as defined in the test, a career path which, as yet, you have not properly and fully relinquished. I must now consider if a sentence of life imprisonment should be imposed. Given your guilty pleas in these proceedings, I believe that this sentence of last resort need not be imposed. Additionally, there are available alternative sentences which can be imposed, particularly in the light of the very long custodial terms those sentences will attract, which will result in you remaining in custody for a significant period of time. The period of time you will spend in custody before being released, subject to license, means that there is some scope for rehabilitative work to be undertaken both in custody and then on license, which may at some future point reduce the risk of further similar offending in your case. This is particularly the case given the age you are likely to be when eventually released on license. Your current risk is not appropriately addressed by a determinate sentence being imposed. An extended period on license is required to ensure the rehabilitative work I have outlined above is completed. An extended sentence will be imposed in your case. Jamie Rothwell, the conspiracy to supply cocaine has a starting point of 24 years in your case, which is increased to 25 years to reflect aggravating features before being reduced to 24 years, applying mitigation available to you. This sentence is reduced further to 18 years to reflect credit for plea and then the principle of totality. There will be a concurrent sentence of 6 years imposed upon you in relation to the conspiracy to supply ketamine. The firearms conspiracy in your case has a starting point of 18 years, which is increased to outside the category range to reflect the 2 conspiracies to inflict grievous bodily harm with intent, for which you also fall to be sentenced together with other aggravating features. The aggravated figure is a sentence of 25 years, which I will reduce to 21 years, to reflect firstly credit for plea and then totality. There will be an extended period of license added to that sentence of 4 years, making a total sentence of 25 years. I shall impose no separate penalty upon you in the circumstances for the ammunition conspiracy. In relation to the two conspiracies to inflict grievous bodily harm with intent, I shall impose determinate sentences of 10 years, which will run concurrently to the sentence imposed for the firearms conspiracy. As I have explained, these all form part of the same series of offenses. The sentences imposed within the two sets of conspiracies, the drugs and the firearms conspiracies respectively, will run consecutively to each other, making a total sentence in your case of 43 years. I direct that you serve the 18-year sentence for the drugs conspiracy first, before then serving the extended sentence of 25 years. That sentence having a 21-year custodial element with 4 years of extended license thereafter. The days you have spent on remand in these proceedings will count in their entirety towards the sentence I have imposed upon you.